morning.
Good morning, Mr. Nelson. This is Paul LaFave. I'm the Vice Chair of the House Natural Resources Committee, and we understand you're going to testify to us on Act 250.
Yes, can everyone hear me okay?
Yes. Yep. I'll let the members of the committee introduce themselves, starting with Representative McCullough.
Okay. Good morning, Representative Jim McCullough from the brave little hamlet of Williston. Thank you so much for helping us today.
Sure.
Good morning, Jeff. Carrie Dolan from Waitsfield.
Good morning.
Paul LaFave from Newark.
Trevor Squirrel, Underhill and Jericho.
Chris Bates, Bennington, 2-1.
Matt Hill, Woolkit.
Tom Terranzini, Rutland Town.
That's all the members present, so this floor
Okay.
is yours.
Great. So I appreciate the opportunity to testify by phone. I'm out of state, and I've been following this very closely and have been very involved in Act 250 issues for many years. So again, by way of introduction, my name is Jeff Nelson, and I am a principal with the firm VHB based out of our office in South Burlington. And I did testify before your committee last February, and in your on your committee website there's a short bio that summarizes my professional background, which I'll just run through briefly. I've testified before this committee many times over the years, and in the course of my professional work have worked with the Agency of Natural Resources, in particular in areas of water quality, stormwater management, and wetlands. And over the years I've participated in numerous stakeholder processes that have assessed and worked on new or revised regulations as they've been considered for adoption in Vermont. I've also been involved in many different design and analysis and permit application for a variety of projects in Vermont, including work for ski resorts, utilities and renewable energy projects, commercial developments, and transportation projects. Much of our experience, and my experience, is working on projects that have undergone Act 250 review. I've worked on cases before all 9 of the existing district commissions, and also participated in many cases before the prior environmental board, and have provided expert witness in various Act 250 appeals before the environmental court. A lot of our work has in fact related to large, complex master plans, including a lot of ski resort work in Vermont. And today I am speaking on behalf of the Vermont Ski Areas Association, which is a nonprofit trade association that represents 20 alpine and 30 cross-country ski area members in the state of Vermont. Molly Mahar, who's the president of VSAA, who I believe is in the room, is best suited to address economic and demographic contributions of outdoor recreation and skiing to the state of Vermont. But just as a summary, I'll say that these industries bring in $2.5 billion a year in consumer spending to the state of Vermont annually and directly employ 33,000 people. So as this committee looks at modernizing Act 250, I would certainly encourage you to remember both the needs of environmental protection and also maintaining this critical economic driver for rural Vermont. Certainly has been the case for many years. So a couple of the themes that struck me from the Commission on Act 250 report that I think are really important as you're working towards a bill. First, I think removing redundancies with other state regulations, specifically A&R permits, is important. Secondly, that finding a way to make the review of Act 250 permit applications more consistent and fair across the state is something that is important to address. And then finally, trying to make the process less complex and more streamlined for efficiency where it can be. These, to me, are all critical concepts, and in order to be successful in modernizing Act 250, they really have to be part of the final proposal. And then, obviously, as you all know, since the work that the committee did last year on Act 250 reform, the administration and DNRC have come forward with a joint proposal that, in my view, goes a long way to addressing some of the needs that I just expressed. So I'd like to kind of go through some of the areas that we've looked at and that we've had some comments for the committee on. And I did send an outline of my testimony this morning to Mark Grimes, as well as a markup of the topic summary with just highlighting of some of the areas that I plan to speak to under the categories of jurisdiction, criteria changes, permits and conditions, and then the new board and appeal process. So that just highlights some of the areas that we wanted to hit on. As an overall summary, I feel that there are significant concerns that remain unaddressed, such as looking at habitat fragmentation as a review criterion under Act 250 and shifting the burden of proof under Criterion 8. I think that the joint proposal otherwise provides a reasonable framework for addressing some of the issues identified for modernizing Act 250. I think the joint proposal's framework for a professional board, its duties, as well as specific cases and how they would be handled makes a lot of sense. And finally, although some concerns remain, I think the joint proposal is a good step forward in looking at how to modernize Act 250. So then I just wanted to go through some of the specific comments that we had based on the topic summary. First, on the topic of jurisdiction, each of the proposals make a change based on elevational features. The committee proposal would result in lowering the jurisdictional elevation under Act 250 from the current 2,500 feet to 2,000 feet, where the joint proposal creates a new jurisdictional trigger for ridge lines above 1,500 feet. In my view, I'm not sure I see a clear necessity for either of these. I see them as a new level of complexity to Act 250 based on my experience, and there's certainly, if you look at ski resorts, they're already jurisdictional under Act 250, so I'm not sure that it really gains a lot in terms of how the regulations would be applied. I do think that if this is something that is going to be undertaken, that the joint proposal is more realistic, and that as long as we have a very clear and understandable definition of what constitutes a ridgeline, that this is something that it would make more sense in terms of how to approach that. In terms of the criteria changes, as I noted in my summary, both proposals would add new criteria to address forest habitat fragmentation, looking at forest blocks as well as their connecting habitat. The joint proposal does include opportunities for mitigation, and both of these would change the burden of proof to the applicant for Criterion 8. So our concern is that both of these proposals would end up with a very large and unknown expansion of review jurisdiction, and there's certainly the potential that these could result in essentially a prohibition of new ski trails or lifts in Vermont, which I don't expect is what the committee is intending to do. So one of the things that we've been thinking of, if this is going to go forward, is that there be a clear exclusion of lands within existing downhill and cross-country ski area boundaries and a reasonable buffer around these. The intent here really would be to recognize the long-range planning and investment that resorts have made and the state of Vermont has made in these very geographically limited areas of the state. I also believe that there needs to be a very clear and available opportunity for mitigation of potential impacts, either through on-site or off-site means, if this is to go forward. And then finally, under this piece, if the proposals to shift the burden of proof occur, we see that as problematic because it's obviously a shift in long-standing precedent, and it's not realistic in that individual applicants aren't necessarily going to have full and complete information or understanding of the larger overall ecosystem concerns and what we've seen in the past is that typically A&R and their experts are the ones that are assessing features on a landscape or regional level, and they're in a better position to be able to assess those and have be able to understand what the impacts would be rather than an individual applicant. So it strikes me that changing this burden doesn't really serve the purpose that may be intended. In terms of the permits and conditions category, the joint proposal adds a 30-day advance notice provision for major permit applications. And I certainly see a lot of value in this. In fact, it's something that we typically do when we're working on large projects around Vermont. I am a little concerned that formalizing it in this way has the potential to create new delays to projects that bring sound economic development. I think within the Act 250 process, there certainly are currently plenty of opportunities for consultation for people that are interested in a project. So I think this is something that should be given a bit more thought. And then regarding the question of presumptions, it's, obviously when Act 250 was enacted, there were no rules, regulations, or standards to address many technical issues associated with land development. And today in Vermont, we have many permits and review processes that address many areas of potential impact, including stormwater runoff, wetlands, streams, rivers, dam safety, water withdrawal, water supply, wastewater disposal, air emission, and highway access. And I think that just making sure that, as the joint proposal does, the presumption of compliance for A&R permits, all A&R permits is maintained, and that the avoidance of unnecessary and duplicative reviews continues, because there's so much work that goes on in developing the materials for the technical permits that are issued by A&R that really should be able to be used in the Act 250 process, continue to be used in the Act 250 process to avoid unnecessary duplication. So then the final topic is the question of a new board and the sort of formulation of it and how appeals would be handled. And I guess as I've looked at it and thought about it, what I see in the committee proposal is in essence recreating the former environmental board model in terms of the additional appeal process steps, whereas the joint proposal creates a full-time professional board handling major cases from which any appeal would go directly to the Vermont Supreme Court. I believe the joint proposal is a reasonable solution to address what I've seen from my experience as the very real and ongoing challenges of inconsistencies, difficulty in addressing complex issues through the part-time district commission model, as well as providing an efficient and timely permit process. The joint proposal also provides the appropriate level of flexibility to handle simple cases efficiently without creating unnecessary and costly processes. I don't think that having all Act 250 reviews being on the record is necessary. Certainly would be considerably more costly to approach it that way. I do think there's some tweaking that may be needed of the joint proposal, wanting to make sure there is sufficient representation and input from regional members, that any opportunities that we've seen through the environmental court model where appeals can be consolidated, that is not lost. And then finally, that there's a clear and reviewable accounting for district coordinator decisions, because obviously the district coordinators will continue to play a substantial role in how specific cases are handled. So that concludes my prepared remarks, and I'm certainly happy to answer any questions that folks may have.
Any questions from any members from the committee? Representative Howell.
Morning again, Jeff. Jim McCullough here.
Yes. Good morning.
This is a question about the on the record, and it's being difficult and costly. as you're well aware, we create a record here in this room every day.
Yep.
And many people, and likely your firm, has accessed those records from time to time to determine legislative intent, which I don't know if your firm has done that, but I'm sure you're aware that is a practice.
Yep.
I'm just curious as to why, or if you think that process that we use here, and in fact this particular suite of Act 250 meetings has been video recorded as well. So I'm just curious why you think that that's a huge and unnecessary and expensive step for creating on the record at the district commissions.
Sure, and I appreciate the question. I guess I'll preface it by saying that I'm not a lawyer, but my experience with Act 250 is that one of the real benefits and kind of ingenious, if you will, aspects of its design is that it's very flexible in terms of the level of process. Many Act 250 applications are very straightforward, they're not controversial, and they can be handled without a lot of formality and process that obviously takes time, effort, and costs money to be doing something in a more formalized way, versus larger projects, which obviously we do have a more formal process. But my understanding of the difference between an on-the-record review versus something that would be, if it were appealed, it would be considered as a de novo review, is that basically there has to be much more careful documentation of exactly how everything is done, much more akin to a court-like process. And I guess my view is that given how many Act 250 permit applications are relatively simple, relatively straightforward, and even if they go to a hearing where it's an opportunity for neighbors to understand the plans and ask questions, and they've certainly testified at many of those, it's not a courtroom-like process. It's really it's not quite a town meeting process either, but it's a much less formal process. And I think if that were to be converted into a more of a courtroom type process, it, in addition to the kind of, as I talked about, the formality of that and the effort of making sure that the records were properly handled, and witnesses were handled as they would be in a court, it just takes away that flexibility and that informality that I've seen time and time again in even projects that do go to a hearing, where various neighbors and stakeholders are able to very informally participate in the hearing process.
Right. Well, thank you for that. I appreciate that part of your answer to my specific question, and while you were doing so, I did hear you. I think that you feel that the district commission process is part of the genius of the original act, with local people involved, and the joint proposal really hacks away at that. If not, some people think does away with the district commission process as you presented it. Do you think there's room for keeping the district commissions within the joint proposal, and empowering them somewhat more, giving them equal representation, but not going as far as an on the record?
I think so. I mean, I tried to suggest that in my final comment about making sure there's sufficient representation from regional members, because I think that while the joint proposal does include 2 regional members in each case, I think their role will be limited, and I think that may be something that the committee and others want to look at a bit more, because I do believe there is value in having individuals who are appointed that are from the area, that really understand the differences between southern Vermont and the Northeast Kingdom, and these are communities that these folks are members of, and I think having that representation continue to occur is really important. And yes, it's part of what I think gives Act 250 the strength and staying power that it's had over the years.
Thank you.
Yep.
Anyone else? Yes. Representative Dolan.
Good morning, Jeff.
Morning.
My question is regarding your question about consolidation of appeals is a good thing, and I do appreciate the interest in trying to be as efficient as we can through all processes related to Act 250 decisions. But we've heard kind of conflicting testimony. Certainly, the joint proposal is trying to reduce one appeal step by having a process by which any appeals would go directly to the Supreme Court after the role of the NRB. And yet, we've also heard that there's, throughout the past number of years, the agency's permit process the agencies would prefer to continue with that existing model if their particular permit is appealed, that they would rather go through the court system because they have now matured into, I think, an effective process for dealing with those appeals. And similarly with municipalities being comfortable and familiar with their appeals process. So I just would prefer if you could elaborate a bit more about your perspective.
Sure, and I appreciate that. And it is an interesting question, because when the environmental court process was changed several years ago in their jurisdiction for Act 250 appeals was founded. I was not sure how that was ultimately going to work out, but I think in the years that have passed, there have been some cases where there's been, say, an appeal of a stormwater permit and an appeal of an Act 250 permit that have been consolidated by the court into a single proceeding, and that has worked fairly well, actually, in my opinion. Obviously the number of those cases is relatively small, and I think that at this point, I'm not sure what the best solution is. I do think that the joint proposal for establishing this enhanced professional board that would handle the Act 250 permit appeals really does make a lot of sense in terms of just the consistency statewide and their ability to establish policy, particularly as we look at new and different criteria under Act 250. But I don't know that there's a role there for that board to be looking at agency permits. I think the court, the environmental court, is doing a good job in sort of being able to review the facts and the law of these. If it's a stormwater permit appeal or a wetland permit appeal, being able to review those. So I don't know that I have a specific answer as to what the solution is. It would be great to be able to to continue to consolidate where it made sense, but I'm not sure the mechanics of how that would happen. And maybe the answer is just that there are so few times when there's an appeal of both an Act 250 permit and, say, a stormwater permit that they have to go their separate ways. I don't know, but that may be the way that it ends up being.
Thank you.
Sure.
Any other questions? Well, thanks very much, Mr. Nelson. We appreciate your time and your testimony. And
Okay. Well, I appreciate the opportunity to testify, and I'm sorry I couldn't be there in person, but the committee assistant knows how to reach me if there's anything further that I can provide.
Thank you.
Okay, goodbye.
Bye-bye.
Bye-bye.